Welcome to our special coverage of the Noor Salman trial here on ClickOrlando.com. I'm Ginger Gadsen. This afternoon, the case could be in the hands of the jury. The federal government wrapped up its closing arguments this morning, and now the defense is taking its turn. News 6's Nadine Yanis joins us live from the federal courthouse in Orlando. And Nadine, a lot to keep up with today, a lot happening.
A lot happening today in court, Ginger. The defense, last we checked, was still presenting its closing arguments. It looked like they just broke, perhaps for lunch, so we'll get an update on that. But the government was up first, speaking to the jury on why they say that Noor Salman aided and abetted her husband, that it wasn't simply that she knew, but that she helped him pull off the attack through words, encouragement, support, and services. And now the government says that they have proven that beyond a reasonable doubt. And it's in these closing statements that we're still learning new things about the investigation that you would think would have come out in trial. But it was today that the government connected some dots for us that they say that Omar Mateen's intended target was Disney Springs, not Pulse, and that Noor Salman knew that. It was the first time we've ever heard the government say in closings that Disney Springs was Mateen's intended attack. Pictures of a baby stroller and a baby doll were shown during trial, found in Mateen's rented van, but the government never connected the dots. Today, the government says Mateen bought that stroller and baby doll to hide his long gun in it and take it to Disney Springs. It's the first time we've ever heard that. The jurors then heard the government overview their case, breaking down in a PowerPoint presentation the 7 lies they say Noor Salman told law enforcement, which plays into her obstruction of justice charge, and then breaking down the 3 acts they say she aided and abetted her husband by 1, creating a cover story, 2, casing City Place in Disney Springs with him, and 3, was with him for lavish spending in preparation for his death. The government using her 12-page written statement as an anchor for most of their accusations. Right now, the defense is poking holes in that theory. Salman's attorney, Charles Swift, walking into court today, says there's one thing he wants the juries to understand.
Charles?
Yes.
There's one thing you want the jury to take away for closing. What would it be?
And we'll hear it in closing. Not guilty.
Not guilty is what he says he is going to argue in court today. I'll talk about the defense. I just want to end with how the government presented their presentation. United States Prosecutor Sarah Sweeney had a beautiful PowerPoint presentation that was concise, boiling it down specifically to the actions they say Noor Salman did, that they believe that she should be found guilty. It was an hour-and-a-half long presentation. It looked like a couple of the jurors, one in particular, might have been a little bit bored or checked out by it. But then back to Charles Swift, that defense attorney, he was much more dramatic in his presentation of closing arguments when I was in there. Basically, it all boils down to this 12-page written statement. And the defense is saying now with this government's new theory that Omar Mateen always was planning to attack Disney Springs and not the Pulse nightclub, that any time that Noor Salman mentioned Pulse nightclub in her statement, saying that she knew he was going to go there and that she cased it with him, that was all false. Charles Swift marking big red X's over that statement, which is what a lot of the prosecution case hinges on, Ginger. Also, the defense also took us through what they say is an apple analogy. They say that when you're eating an apple, if you get 2/3 of the way in and there's a worm in it, you're going to get nauseous. You're going to throw that apple out. Well, he says that written statement is the bad apple in this case and that the jury should throw it out. And in hindsight, that could bring down the entire government's case. A lot of semantics, closing arguments, hitting the points home for the jurors as we speak in federal court. Ginger?
Yeah, and Nadine, I know, the Pulse survivors and the victims and their families, they don't want that apple thrown out. They simply want to get closure after this attack.
That's right, Ginger, and I actually just briefly spoke to some of them, and they tell me the whole time that they wanted to come here for answers and that they did get some of those questions answered. If you take a look, several of Pulse families and survivors were here, including Barbara Poma came today. A lot of them, like I said, they wanted to be here throughout the trial to find out more about how their loved ones died and, of course, to find out what will happen to the Pulse gunman's widow. Christine Leinonen was also here today. She was here for the beginning of opening statements. She hasn't been able to come back, but she said for sure she wanted to come back today to see what the government is presenting.
So we'll be really telling what the evidence was, since I wasn't able to come every day of the trial. Now I will be able to see exactly what each side thinks that they did prove.
And it was just about 5 minutes ago, Ginger, that I spoke to Tara Connell. Her son, Corey Connell, was killed outside of the Pulse nightclub. She's been here almost every day for the trial. And when I asked her, did you get those answers that you wanted? She said yes. She said that it threw her for a loop that Noor Salman was never physically here in Orlando or cased the Pulse nightclub. And she said she's happy she learned that, because if the jury comes back with a conviction or a decision that they did not want, if they come back that Noor Salman is innocent, Tara Connell, this Pulse mom, said that she would understand why now, and that she wouldn't be as upset because she has sat in throughout this entire trial. But that's all going to be up for the jury to decide. It's very soon that they could have that jury verdict form in their hands and break for deliberations. We do know that it looks like they broke for lunch, and that the government's going to have a chance to do a rebuttal closing. They're the ones that have the burden of proof beyond a reasonable doubt that Noor Salman is guilty, so they'll get a second round in closing arguments, and then Noor Salman's fate will then be in the hands of the jury. Ginger.
Yeah, Nadine, it's interesting that you bring up Corey Connell, because he's one of the ones that we really can relate to, because he was a worker at Publix, and so many people had contact with him and said what a nice guy he was. And it's for people like that who just want closure, and they want justice for people like Corey. And of course, his mom, Sarah, there today to hear the closing arguments. Nadine Yanis, thank you for that live reporting. And joining us now is our News 6 analyst, Jason Johnson from Lowndes Law Firm. Thank you so much for being here.
Great to be here.
A lot to digest today. How do you think it's going so far? And it's a case where they're presenting new evidence in closing, especially we had not heard about the baby stroller being used perhaps to disguise a long rifle. What do you say about that?
Well, I think it's important to note that there's a difference between evidence and argument.
Sure.
The baby stroller was already into evidence. It was admitted as part of the government's case in admitting photographs of what occurred. So the baby stroller was in that photograph. It was admitted into evidence, but we didn't know the significance of that until today.
It was never talked about, really.
Correct. They didn't elicit any testimony from any of the witnesses about the significance of that baby stroller, but they certainly tied it together with Noor Salman and his efforts to case Disney. And I think we shouldn't be that surprised that the government stated unequivocally in its closing statement that Mateen's target was Disney, and it was always intended to be Disney, and she knew that. It kind of pulls the teeth a little bit on the fact that she didn't actually go to Pulse with him. I think we knew from the defense's motion in limine that they filed at the beginning of the trial, where they recite some of the forensic evidence that didn't support the part of the written statement where she says, I went to Pulse with Mateen. And that forensic evidence disclosed, I think for the first time to the public, that he had gone to Disney Springs first the night of the attack, and then left there to go to Epcot before finally coming downtown and attacking Pulse. It was pretty clear from that motion that his intended target was always Disney Springs, and that it was the presence of those armed officers out at Disney Springs that prevented him from attacking or made him rethink attacking Disney Springs. It was pretty clear to me at that point that their argument was going to be his target was initially Disney Springs. He found out there was too much security there, so he came downtown and ultimately decided on Pulse because he thought it was a soft target. He didn't see any armed security outside. We heard that testimony yesterday that the security guard said he came in, asked if he was a security guard, was trying to determine whether he was armed, because Mateen was trying to decide, is this a soft target? Am I going to be able to successfully attack this target? So I don't think it should be surprising that the government initially made the argument or tied it together in its closing statement that Disney Springs was the target, and using the baby stroller tied that in. Nobody would be surprised to see anybody pushing a baby stroller around Disney Springs.
Of course not.
There would be no reason for him to have that baby stroller in the car with that baby doll if he were always intending to attack a nightclub, because you wouldn't walk up to the front door of a nightclub at 2 a.m. with a baby stroller. So it was pretty clear that his intent was always to attack Disney Springs, which I think would have made for a very different story for this community, not taking anything away from the magnitude of what occurred or the magnitude of what occurred to the specific gay and lesbian community by attacking Pulse. But I think we'd be a different story had he attacked one of our primary tourism centers.
And could that be the reason that they saved that for the closing arguments as opposed to presenting that using that during the actual trial?
Well, I don't think they needed to raise it during trial. It was certainly something they could have raised during their opening statement to say, here's the evidence we're going to show that he intended to attack Disney Springs. But they did it, I think, also in an effort to pull the teeth or undercut the defense's argument that, hey, look, this portion of the written statement where she says, I cased Pulse with Omar, it's just immaterial because the government doesn't have to prove that she helped him plan the attack against Pulse, or she helped him carry out the attack against Pulse, or that Pulse was even the intended target. They have the evidence showing that she went out to Disney Springs with him. There's forensic evidence that proves she was there. She wrote in her written statement that she was there. So the government was always intending to rest on, hey, she helped him plan this attack. They don't have to show that she helped him plan. All they have to show is that she provided some material support in the carrying out of the attack. They didn't charge her with conspiracy, which would have been planning and carrying out the attack. They charged her with aiding and abetting. Did she provide some material support to him, some aid that helped him carry out this attack?
Have they done a good job in presenting that?
I think there is plenty of evidence for the jury to convict her on that, even without the written statement. Now, clearly the government is relying heavily on that written statement, but it sounds like they did an excellent job in their closing statement of checking off.
The Apple analogy as well?
Well, the Apple analogy is the defense's analogy that, hey, look, you've gotten through two-thirds of this written statement. The government showed you two-thirds of the written statement that looks good, and it's backed up by the forensics. But then you get to this one-third of the apple, the part with the worm, where she says, I went to Pulse with him, and that's demonstrably false. And so once you get to that part, you have to throw away the whole apple.
Sure.
It's a good analogy for them.
Yeah.
It paints a nice picture in the head. It's something that the jurors can easily wrap their minds around. But I think the jury can discount that part of the written statement. They don't have to accept all or none of it. It's not an all or none proposition. They can say, we thought she was lying about that part, but we thought she was telling the truth about the rest of it. And the rest of it is backed up by the forensic evidence. And that's enough to convict her of aiding and abetting. And they went through all of the times where they said she lied to the FBI and laid out their obstruction of justice count as well. And remember, there's two charges here, not only the aiding and abetting charge, but the obstruction of justice charge. And if they get her off on the aiding and abetting charge, there is still a maximum penalty of 20 years for the obstruction of justice charge. So the defense really has to hope that the jury just completely discounts the written statement. Because if there is no written statement that has any validity to it, then they can't get her on obstruction of justice. They could still potentially get her on aiding and abetting, but I think their hope is if we can get the jury to completely discount the written statement, she'll be acquitted of everything.
Yeah. Now, okay, so we're not in the business of reading tea leaves, and it would be almost impossible to do here, but if we were to put you on the spot, like I'm doing right now, and ask you what you think will happen once the jury gets the case.
Well, I hope that they are deliberative in their process of deciding her fate. There are two charges. Judge Byron will charge them, meaning he'll read the jury instructions to them, and that's the charging of the jury, telling them, here's what you need to do, here's what the law is, here's how you need to apply it to the evidence. You need to look at all the evidence. You need to remember that the government has the burden of proof the entire time to show that they proved this beyond a reasonable doubt. She starts with a clean slate. They don't have to prove anything. They don't have to put on a case. You can't hold it against her that she didn't testify. It's not an indication of any guilt. Hopefully they go through that process and look at all the evidence in deciding. I'm not going to predict whether I think she'll be convicted, but I will say that I believe there is sufficient evidence to convict her on both counts.
Okay, well, we will find out sooner rather than later because we are getting very close to the end here. Thank you so much for your insight and analysis as always. And News 6 and ClickOrlando.com will have reporters at the trial every single day, and we have a special page detailing everything that happens on ClickOrlando.com. Just look for the Noor Salman trial. And join us tonight at 6:30 for another discussion with News 6 investigator Mike DeForest and legal analyst Mark O'Mara. You can watch it live right here on clickorlando.com. Thanks for joining us this afternoon, everyone. I'm Ginger Gadsen. We'll see you later.